I'm James Swartz, managing attorney at Swartz and Swartz. So after a child's injury, I'm James Swartz, managing attorney at Swartz and Swartz. So a child's injury can be particularly stressful, of course, for family members, especially parents. Massachusetts has very specific rules to follow following a child's injury if it's determined that that injury was caused by someone else's negligence. First, in order to pursue a claim in court, a parent or guardian has to be involved. That's because under the law, a minor child doesn't have standing to file a claim. So that claim is filed on behalf of a parent or guardian in order to seek justice and a recovery for the child. If a lawsuit is filed by that parent or guardian, certain types of damages are recoverable. Those damages include actual medical costs for care relating to the incident, also potentially future medical costs for very serious injuries. Those can be determined by medical economists or life care planners. Among the recoverable damages are medical costs, both past and future. For future medical costs, experts are typically involved to determine and calculate what that care will be and what the cost of the care will be as the child gets older. Typically, those cases involve very severe injuries, such as brain injuries or spinal cord injuries, where it's clear that a child's ability to pursue a certain path for education or career is significantly impacted. Other types of recoverable damages include what are known as non-economic damages. So, for example, pain and suffering, and even how your child feels on a day-to-day basis, or the effect of pain on your child for significant injuries moving forward. There can be mental anguish damages and loss of enjoyment of life. So certain hobbies or activities that your child enjoyed or that you enjoy with your child can be the focus of damages in these cases. For cases brought on behalf of minor children, in Massachusetts and most states, there's significant judicial oversight to make sure that the child's interests are protected. What this means is that a judge will be involved not only early on in the case, but when a case resolves and there's money to be distributed to the child. And that's to ensure that that money goes to the child and the child alone for the child's needs at present, and also for any future needs when there are severe injuries involved. So the judge at the conclusion of a case will want to be sure, as mentioned, that the money is paid for the benefit of the child. So there are three main ways that that can occur. One method is through a structured settlement, which means essentially periodic payments made by the insurance company. And typically there are tax benefits to doing it that way as well. Another method includes a trust account. So a separate trust document would be set up, and then the money is deposited into an account in that trust name. And the terms of the trust make clear that the money is for the benefit of the child. Finally, in some cases, a guardianship can be set up involving a parent or another adult, so that an account at a bank, for example, can be set up by a parent for the benefit of the child. And the funds from the settlement can be deposited directly into that account. Regardless of which method is chosen, a judge at a hearing in court will look at that method and make sure, again, that the child is protected. So if you have questions about the potential for financial compensation after your child's injuries, contact Swartz and Swartz.